Hello, class. My name is Julia Terrones, and I'm doing my project on topic 7, competence to be executed and to participate in and waive appeals. I wanted to start off with this quote, parents patriae, meaning state as a parent, because the state has traditionally made decisions for those unable to take care of themselves, and they've been traditionally doing this for years. And this is basically my understanding in a quote from the textbook of what competency means. Starting off, we're going to start off with this court case, Godinez versus Moran. Starts off with a man, Moran, who shot two people in a Red Pearl saloon in Carson City, Nevada. He shot a bartender and a patron. He then proceeded to rob the cash register. And 9 days later, after his spree, he decided to arrive at his former wife's apartment. He arrives at her apartment and opens fire on her. He shoots 7 times but hits her 5. After shooting her 5 times, he decides to shoot himself in the abdomen and attempt to slit his wrist. Unfortunately, he's unsuccessful at slitting his wrist, and at the hospital admits that what he did was wrong. Moran wished to represent himself at the time, but psychiatrists had determined that he was depressed after the crime and still found him competent. Moran wished to represent himself eventually, and simultaneously, because he was taking prescription drugs at the time, the judge questioned his acts of why he was wanting to represent himself and found that he was incompetent to advise that information to him because of the side effects of the medication causing memory impairment, lightheadedness, drowsiness, and depression and confusion. Moran eventually stated he knew the importance of waiving his constitutional rights, understood the charges against him, and was guilty. But yet, when the judge ends up mentioning what the meaning of premeditated or deliberately, he acts confused. He's unsure of what that means. He questions his answer. He then says that he was not looking to kill her, but she ended up dead. Eventually, at the end of that court meeting, he admits of what he did and ends up guilty. Legal tests is my next slide. So I wanted to bring this one up because it talks about the Eighth Amendment. The Eighth Amendment is banning cruel and unusual punishment and prohibits the execution of an insane person. Yet each state and different courts have a different meaning of what is classified as an insane person. I know in the American Psychiatric Association and the American Psychological Association endorsed a broader standard, a standard that calls for exemption from capital punishment for any individual with any mental disorder or impairment, and produces a more medical treatment versus a punishment. The ABA's criminal justice and mental health standards recommend that a prisoner is able to obtain independent evaluation, and the counsel represents the prisoner at the competence hearing, and that the burden is on the prisoner to show incompetence by a preponderance of the evidence standard. Florida, on the other hand, understands the nature and effect of the death penalty and why it is to be imposed before execution may take place. So that person needs to understand what caused him to be put up for death and why he is being charged that way. This last quote that I put, this last quote that I put is kind of, well, it was very important for me to put in the slide. So I wanted to read this one directly off. If an individual is waiving the post-conviction process is competent to do so, the Supreme Court has made clear that the waiver is valid so long as it is knowing and intelligent, meaning that the individual realizes the importance of his decision. So once again, this chapter is highlighting competence to a full extent. You have to understand why you are being convicted, what your actions were, why you're being charged that way, and you need to know what's the meaning of your decision if you're deciding to waive your post-conviction process. If you're deciding to waive an execution process, you need to know the importance of what's going to happen to you afterwards and why you're doing that. Evaluation issues. So this is going for more of the psychiatry side, the medical side. So issues are arriving because possibly due to the checklist not being thorough enough, people not finishing the checklist, not really meeting a one-on-one in a proper space, a proper setting, one where the inmate feels comfortable. If an inmate doesn't feel comfortable, they will act irrationally, possibly not give you answers, and not conform with your ideology of trying to make him understand for his benefit and not your own. I just want to give an example. I work at a police department and I interact with a few, not a lot of irrational people, but I do get a lot of people who are not in the right state of mind. Most of these people are very irrational, not because they were just born that way. I do believe that there are underlying conditions that they could possibly need treatment with. Most of them are homeless, so I can only imagine the other issues that they're going with too, as well as housing. A lot of the housing projects in in the city that I work in are very full, so they have to constantly wait. But trying to understand these people is very hard just because you want to help them, but they don't see it in your way. They see it as you're just trying to ask me questions and get me in trouble and throw me in jail. They don't see it as you're trying to help me because you care and I need help. So please, they don't see it that way. There are some, I would say it's very rare, when they actually come into the department and they need help. But unfortunately, there's only so much that our department can do. And that's the sad part of it. Coming back to the evaluation issues. So we're going to talk about more about as as the checklist goes. So the top of the checklist is first getting to know and understand violations and understand the person. The bottom half is going to be more of an evaluation and trying to get the person to comply and understand more of his rights, proper procedures, and so forth. Okay. Competence issues can occur in capital cases after the conviction and sentences have been imposed. First, the defense might object that the defendant is incompetent to assist counsel in post-conviction proceedings. So this act can happen afterwards. Not all evaluation issues can happen before the initial contact with this person. They can even happen afterwards. That was one thing that I understood that was a bit confusing for me. Taking it back and knowing like the fact that being competent that can change. You can be listed as competent at the beginning of your initial initial meeting, but incompetent by the end. Oh, sorry. Like we talked about. Second, as just discussed, a defendant may waive the right to post-conviction hearings against counsel's advice. They don't want to hear it. A defendant is going to waive his right because they already know what's going to happen, or they don't want to hear it. Final competence issue is the competence to be executed when the death warrant is signed. A death warrant could be signed by a judge. Hopefully, I wouldn't think that would be possible, but this is based off my knowledge. I would believe he or she would have to physically sign it because it is involving them and their paperwork. Execution competence domains are one, inmate's awareness of the punishment and execution. I cannot stretch this enough because inmate's awareness is 100% the main structure of this chapter. It's competence, understanding of what's happening, your punishment, your execution, awareness of why you're going to suffer that punishment, awareness of why you were sentenced that, and the ability to assist counsel. So you need to be, or they need to be, very vigilant of paying attention to their council members, understanding of what's happening. If they're not, it's more of evaluation issues, more of whether you're going to be seen as competent or simply they're just going to decide for you, unfortunately, or get you more on the medical side because competency seems to lean between both. And then my final one is treatment. So the document that I posted is from the LA Times and it's based off Charles Manson. In this article, they briefly describe Charles Manson needing medical help, but it seems that he's not reluctant to know what is happening with his body and doesn't seem that he wants treatment. A lot of people were reaching out and wondering, where is he getting treatment from? They knew he was in the hospital. Charles Manson's a murderer. He is a very high profile murderer from the 70s, but because of that, he is very popular. He's a bit of celebrity in the murder era, serial killer era, I suppose. I wouldn't consider him a serial killer. But this is where I wanted to bring up my question. In the case of Charles Manson, where he was given he was given treatment for his colon cancer while on death row, do you believe inmates who are sentenced for heinous crimes should be allowed to receive treatment for underlying conditions? Why or why not? That's for my class to decide. I just wanted to talk about the treatment in general because treatment is very it's a very what is it? Um, sorry, I'm losing my words right now. It's a very controversial topic when it comes to competency in my views and understanding of the text. Treatment in some areas is seen as useless. It is also seen as necessary, especially from the National Medical Association. It's held the physicians should always provide needed treatment regardless of a prisoner's legal situation. Bit of first responders answer. First responders, their job is to always assist, treat, help, just because that's their job. That's what they signed up for. Police officers, same thing. As soon as they are initially the crime has stopped, their job is to be a first responder and get that person the help that they need, regardless. That is protocol. Treatment is also seen as contradictory because the argument that medicating a death row inmate is not in his or her medical interest. A lot of these people who are on death row or have life sentences do not see the point in getting medical help just because of the situation that they are in. Unfortunately, because they they're just at that point in life, and you can understand that. Um, and a lot of different places seem like they don't want to spend tax money or the prison's money or the hospital money to get these people the medication and help that they need just because of the medical state that they're at and the physical state, possibly just because of how many years they possibly have left. Charles Manson, for example, he was set to be seen in court at the age of 92, yet he didn't make it. He only made it up to 82. So the lifespan of these court cases as well don't really reflect on how long people have to live. Medication can facilitate challenges to the death sentence and underlying conviction, and the mental health professional is not placed in as a vulnerable position ethically because the medical health professional is just trying to help. So regardless, that's just their job. Even if they say in the back of their head they don't want to, they have to do it. Um, yeah, and these are my references. I only use the textbook. Thank you.